Welcome back. This is your host, Kristi Slaughter on SuperTalk Saturday mornings, WFHG 92.9. Thank you for tuning in this morning. We are with our special guest, Jeff Clayton. He is the Executive Director of the American Bail Coalition. Good morning, Jeff.
Morning. Thanks for having me on.
Thanks for being back with us. There has been lots of activity since we spoke to you. Get us up to date.
Well, there has been, and I actually got out of the ski lodge I was skied in last time. And then what's happened is a couple of key things. Number one, the movement against the use of computer algorithms to decide bail has exploded as an issue, and is probably the number one issue out there. The other, I guess, kind of a 38,000-foot view of what's happened is that in the legal cases, Walker versus Calhoun, Georgia, the Supreme Court refused to hear a case where the use of bail schedules and the use of bail was upheld by the U.S. Court of Appeals for the 11th Circuit. And then finally, on the legislative front, we've really seen a slowing down of bail reform in some places. California passed a massive bail reform that we can talk about. Bail reform was considered and rejected in Tennessee, actually. And most other states are kind of slowing the train down a little bit from what we saw maybe a year ago.
Jeff, let's go ahead and talk about California Senate Bill 10.
Absolutely. So what Senate Bill 10 did was to basically create the federal system of bail in California. But what it really did was use a computer risk assessment algorithm to put people into three categories: low risk, medium risk, and high risk. Low risk, you pretty much go home. Medium risk, they created a massive statewide bureaucracy of free trial services programs with free conditions, meaning all ankle monitors and everything would be free to defendants. And so judges would just trammel people's liberties with all these other things like house arrest and all that sort of thing. And then if you're high risk, you're in jail, no bail, you're locked up, throw away the key. And so what happened was basically civil liberties groups, and obviously would take out the right to bail as we know it in California. And so all the bail folks opposed the legislation. 50 civil rights groups, including the ACLU. And ultimately, because it was a deal cooked up by the governor and the Chief Justice and the leadership, in the House and the Senate, it became law. And so what we did was, in California, you can have the voters, collect signatures and get a ballot initiative going. It's called a referendum drive to overturn it. And that's ultimately what we did. We collected over 395,000 signatures and turned them in less than 90 days. And so the law is stalled out, and it will appear on the November 2020 ballot, and the voters will get to decide.
How does that affect us as a nation, Jeff? What's happening?
Well, I think the reason we have bail, the reason there is a right to bail, is because really five dukes in medieval England refused to loan the king money. And he threw them in jail, and there was no bail, and they didn't get out. And so that led to this tradition of bail that we have, which is the use of, incarceration against political opponents. And I think in the times that we're in right now, you could imagine that happening, where a particular party in power in a particular state or the nation were to abuse it. And I think the right to bail is fundamental. And what it means is that we don't care about the Eighth Amendment. We don't think it's important, and we don't think the right to bail by sufficient sureties means anything, and we just think it's bad and we should get rid of it. And I think that's terrible for the country.
Jeff, you mentioned the algorithms that are used to assess risk. What types of things do the algorithms look at? How is the information compiled?
Well, yeah, that's a good question. Sometimes we don't know, but what we know in general is that they use what's called regression analysis, which is basically figuring out what factors correlate with people committing new crimes or failing to show up in court. And so, normally factors include things like, prior crimes, prior failures to show up. There's been some algorithms that use demographic factors, meaning things like, do you own your home or not? Do you rent? Do you have a cell phone? Do you have a home phone? Demographic factors have been criticized, obviously, with correlating, with bias in the criminal justice system. And then there's other ones. There's one in Colorado that uses mental disability as a factor, which we think violates Americans with Disabilities Act. But anyway, they're all over the map. And like I said, it's fancy math that generally we don't get to see.
That's one of the things that I think is very interesting, Jeff. Most of us do not know that this really exists. And is there an issue with our personal rights and privacy when this information is being put together and then used, possibly, which could benefit us or potentially could be a detriment?
I think it's a major problem. And the reason it's a major problem is because the data is derived from the FBI's crime files, in part, and the state Bureau of Investigation where they're running these things. And so what are they doing? They're taking all this data about people. They're putting it out on a cloud in some cases because they're letting vendors run some of these things. And it's all out there. And the security on it's pretty loosey-goosey in my mind, and we're not even really too worried about it. And I tried to get behind the curtain here in my home state in Colorado, and they told me, no, we can't give it to you because it's FBI crime files, meaning that nobody gets to go in and check the math. So it is pretty scary, and I think that's why we saw legislation out in Idaho, House Bill 118, to force these things to be transparent, which is the number one thing we need right now.
So do you think that other states will pretty much follow suit from that?
Yeah, they have been. They've been slow to start, but I think a couple of states are really on the cutting edge of this. I think in New York, the civil rights group sent a letter to the governor saying it's a non-starter, don't even bother, bringing out a risk assessment algorithm, so they didn't. But I think a lot of attention is being paid to this issue, and I think over the next 2 years you're going to see a lot of legislation. I've been with the American Bail Coalition since May of 2015, almost 4 years now.
What have you seen are some of the major, and we've talked about a few of those, but what are some of the other major shifts that you have seen since you started with the coalition?
Well, I think the big one, other than risk assessment algorithms, and like I said, just to give you an idea on that one, if you went into a room in 2015 and said that you didn't like risk assessment algorithms, you were banned and never invited to come back. That's how dramatically that issue has changed. But the other one is preventative detention. This idea that we are going to give the state the power to lock more people up, and therefore that's going to solve mass incarceration. It doesn't make sense on its face, and it doesn't make sense in practice. And so states that were all gung-ho about changing their state constitutions, only two of them did at the end of the day, which was New Mexico and New Jersey, to kind of implement this no-money bail system. But the rest of them have said, no, that's a bad idea. And that is a major reversal in trends, and I think points to the idea that there needs to be bail in the system. We can all kind of debate about how much bail should be imposed or not and for what crimes, but the idea that we should get rid of it and that we should go to the no-money bail system, I think is starting to fall apart.
Jeff, here in just a couple minutes, we need to take a quick commercial break, but I'd like to talk about the U.S. Supreme Court refusal to hear the Walker versus Calhoun, if you don't mind. Can you stay with us?
Absolutely.
Okay. We'll be back here in just a few minutes. This is your host, Kristi Slaughter, on SuperTalk Saturday mornings, WFHG 92.9. Welcome back. This is your host, Kristi Slaughter, on SuperTalk Saturday mornings, WFHG 92.9. We're back with our special guest, Jeff Clayton. He is the Executive Director of the American Bail Coalition. Thanks for staying with us.
You got it.
Okay, Jeff, before the commercial break, I mentioned the U.S. Supreme Court refusal to hear the landmark case of Walker versus Calhoun in Georgia. Talk to us a little bit about that.
Exactly. Maurice Walker was a guy who had a severe alcohol problem and was walking in public roadways, I believe 2 or 3 nights in a row. And the police took him home the first couple of nights, and then the third night, I believe, he was walking on a public highway, highly intoxicated, danger to himself, and they took him to jail for public intox. The city of Calhoun, Georgia, had a bail schedule at the time. His bail was set at $160. At the time, it was a holiday weekend, and so Monday court wasn't going to happen until the next Monday, and Walker couldn't post his $160 bail. So the city was sued because the bail schedule discriminated against the poor, because somebody who had the $160 could get out. And the city at the time changed their policy to hear all cases within 48 hours. In other words, Walker wouldn't have sat for 8 days. He could have, 2 days later, within 2 days, seen a judge and argued that his bail was too high. And so a federal judge ruled that if somebody sits 1 second longer, in other words, if Walker sits 1 second longer than Jeff Clayton, who has 160, then that's unconstitutional. And ultimately, the 11th Circuit said, no, that's not the right answer, that the new bail policy allowing for a bail schedule and for review within 48 hours of somebody's financial circumstances or otherwise is constitutional. And the U.S. Supreme Court refused to hear the case, which means that we can all kind of take a deep breath and realize this is good law now, that as we knew all along, you can have a bail schedule. It's just you have to have give somebody an opportunity to have a meaningful argument that the bail should be reduced in a quick time period.
Okay, Jeff, what do you think are the key components to resetting the bail process that we have here in the United States, and how can we make sure that we're taking care of making sure that the Constitution is being followed, and at the same time reevaluating maybe some things that we have missed in the past?
Well, obviously when you're in a big public policy debate, people always ask you, what are your solutions? And so that's an exercise that we went through last fall. And so if you go to our website, we have at ambailcoalition.org, we have the fourth generation of bail reform in America. And there's sort of basically 14 principles of returning the system to what it's supposed to be. It's not supposed to be a system of probation and supervision and punishment, which in many cases it is. It's not supposed to be used for the state to enrich its coffers. In other words, as a collections mechanism, which it is in many states, state of Indiana being a prime example. So we are trying to return the bail system to sort of a more pure system where there's not all this little monkey business of using it for what it's not supposed to be used for. And, that does include, looking at things like nuisance bails, the bails in, the Walker case. Some of those probably aren't necessary, and we should think about that. That if the ultimate penalty isn't jail time, why are we arresting people unless they're a danger to themselves? So, we think we have an answer, but we think, working within the existing Eighth Amendment framework and the existing state constitutional framework is something that we advocate for, because we think there's a lot of room for change within the current system without, upending the whole thing and causing, chaos like down in New Mexico.
Jeff, you have a wonderful website. Again, if you don't mind to give us that information, what's the website address again?
Yep, it's ambailcoalition.org.
And on there, you have all sorts of different things, such as frequently asked questions and also myths. What's probably one of the top myths that we've accepted as truth as far as bail is concerned?
Well, I think it's just the media talking point that, and I could write these articles. Basically, they go something like this. He's rich, he's poor, he stayed in jail, it's not fair, he was innocent, and therefore that's wrong. And there's a lot more going on in bail, because bail, I think the number one thing people think is that judges just ask how much money do they have on them, and that's not how it works. It's third parties, moms, dads, friends, family, probably 90 to 95% of the time that is posting bail. So it really, if we're asking, can the defendant afford bail? Well, probably not. But really, it's a test of his ties to the community. And does the community believe in him? And do they want to put up for him? And if they do, he gets out. And that's, I think, the number one myth is that, people don't realize that third parties bail people out generally.
Jeff, you also have a section on your website that breaks down information state by state, which I think is very helpful and interesting to people who want to be able to be an advocate for this cause, or at the same time, just if they're curious about what's happening from state to state that's maybe not making national news.
Yeah, we do, and there's, I think Tennessee would probably be a prime example of what's not making news, but was happening, which would have been a major ordeal, which is, allowing for sealing eligible offenses of certain categories to just get no bail. And that was legislation that was run in Tennessee this year, which would have created a revolving door at the low end and taken away discretion from judges. And I don't even think it got very much of a headline.
Well, thank you for all the work that you're doing for the information to be accurately distributed, and I'm looking forward to having you back on as some of these changes are being made in individual states that are affecting us throughout the country. Is there anything else that you'd like to share with our listeners today?
No, I just wanted to thank you for having me on again. It's always a pleasure, and look forward to doing it again.
Well, thank you so much. Happy Easter weekend.
You too. Take care.
Thank you.